So how is everybody doing tonight? Good. My name is Curry Sautner. I'm the Vice President of Visitor Experience and Education here at the National Constitution Center. I see some faces that I recognize from other talks, so it's lovely to have you all back at the center. This is going to be a wonderful night, and I'm very honored to be the one introducing these two fine ladies. First of all, I can't talk about what we're about to talk about without pointing out that Carol Berkin is here. And just so you know the history that the Constitution Center has with Carol Berkin, it's very long, and it's way before our building was built. She was one of the original scholars that helped design the idea and the concept around this building, around the exhibits in our space, and around the great program we have here. So I feel very honored that she's back on our stage and really talking about one of the things that we love so much as citizens and as people of the Constitution Center, the Bill of Rights. The other really amazing person that's going to walk out here is Julie Silverbrook. She is the Executive Director of ConSource, which is an amazing resource online, and I'd love for you all to go home tonight and look at it if you haven't already. It's an amazing resource that allows you to dig into the constitutional documents and the historic documents and really see the connections between the past and the present and how they affect our lives today. But that's not the point that I wanted to point out. We have amazing women, we have an amazing content, and we're going to let them go and really inspire you about that Bill of Rights that is almost 225 years ago. There's one thing that seems a little off, or maybe would have seemed a little off to the Founding Fathers 225 years ago. 3 very smart, intelligent women, including myself, up here talking about the Bill of Rights. We have come a long way, baby, and I think it really shows. So, without further ado, I'd love to introduce you to two of my really good friends and two brilliant women. Could you please welcome Julie Silverbrook and Carol Berkin?
Thank you.
We're going to take you on the road with us, Curry, I think.
Yeah.
Thank you for that really generous introduction. I am so thrilled to be back at the Constitution Center today to discuss with all of you my very dear friend Carol Berkin's fabulous new book, The Bill of Rights, The Fight to Secure America's Liberties. The books are on sale, and Carol will be signing them for a little bit after today's program, so I encourage you to purchase this wonderful book and make sure that you get Carol's signature, legendary signature for the Constitution Center before we begin. It's a particularly timely conversation for me because today is actually the 10th anniversary of the founding of the nonprofit that I have the privilege to run, the Constitutional Sources Project, or ConSource for short. And we actually launched here at the National Constitution Center. So it's fun to be at our birthplace, so to speak, on our actual birthday, talking about constitutional history and the Bill of Rights legislative history in particular. It's a area where I've spent a lot of time studying, in part because we actually have the legislative history of the Bill of Rights in our free digital library at consource.org, which I encourage you to check out. You should also read Carol's book, which translates that legislative history into a really compelling and vivid narrative in a way that I think really only Carol can. If you haven't read her book, A Brilliant Solution About the Constitutional Convention, I highly recommend that you pick that book up as well. I think this is a wonderful complement to that. And without further ado, I do want to get into our first question here. Carol, but before I do, one logistical note, somebody, if they haven't already given it to you, will pass out 3x5 cards. If you have a question, please write the question onto the 3x5 card. And when we have about 25 minutes left, I will start asking Carol some of the audience questions. Now, Carol was at the National Archives in Washington, D.C. earlier this afternoon, and I heard she had some really thought-provoking audience questions. So I hope here in Philadelphia, we also have some really thought-provoking questions. So don't be shy with those. So with that, Carol, before we really delve into the legislative history, let's talk a little bit about a broader question, which is the difference between our modern understanding of the Bill of Rights and the understanding that the men who drafted and ratified the document had.
I've taught for 40 years. I started when I was 7. I've taught for 40 years, and the thing that really, one of the things that inspired me to write this book is to realize that my students all assume that from the minute the Bill of Rights was written, it was the most important statement of the values and ideals of American history, and everybody admired it, and everybody hoped to see it followed religiously. The truth is, of course, that once it was ratified, it was completely ignored for almost 75 years. So I thought that is what sparked my interest in what was going on. Why was it written if it was so unimportant and so powerless that no one paid any attention to it until after the 14th Amendment? And so our reading of the Bill of Rights, that is, its importance, is completely different from their understanding of it. Secondly, a lot of the things in the Bill of Rights that we interpret in our modern sensibility after 200 years of court decisions and historical events and political party statements and platforms by party is different from what they thought they were doing when they wrote the Bill of Rights and what they understood it to be. And all historians have sort of metaphorically tattooed on their forehead, the past is a foreign country. And the goal is to try to understand things as they understood it and not as we understood it many, many years later.
But in some ways, don't you think that the modern preoccupation, the passionate belief in the Bill of Rights, in some ways actually satisfies what Madison was sort of hoping for with the document?
Absolutely. If Madison were alive today, which he is not, if Madison were alive today, he'd be amazed that you and I were on this stage. He would be overwhelmed. I'll get into it a little bit. His original goals for the Bill of Rights were an amazing combination of down and dirty practical politics and incredible high ideals. Madison is a fascinating person exactly because he is able to sustain in one campaign both very astute, very tough politics and an incredible idealism. And the idealism piece of this came after the politics of it. He decided that the most dangerous thing in American society in 1789, everyone who was a political leader feared tyranny. Most of the men who had done any reading about past republics, the Roman Republic, for instance, knew that they always ended in tyranny, that they always declined, that they always wound up with some kind of tyrant, and they assumed that theirs would also. They assumed that the United States would wind up some kind of tyranny. Their goal was to delay that as long as possible. Madison's opponents thought that the danger would come from the government itself, that the federal government was a setup for tyranny, that it was going to plot and plan first to create a monarchy and then to create a corrupt monarchy. Madison, on the other hand, thought that the greatest danger was not the federal government. The greatest danger was the majority of the citizens, who he believed would oppress the minority to satisfy its own interests. And this is what he worried about. You can see it in the 10th Federalist, but you can see it particularly in this campaign about the Bill of Rights. That what he was concerned about was how could we protect minorities in America. He was not thinking about African Americans. He was not thinking about women. He was thinking about white men who were members of a small religious sect, or white men who had different attitudes from the majority of the people in their community, in their state, in their town. And he thought the Bill of Rights, or the amendments that he was proposing, the statement of the people's rights, he knew the federal government had absolutely no power to enforce them, which they didn't have until the 14th Amendment. But he said, if we can get people, and he did not use this word, but he meant, if we can get people to internalize the values that are in this statement, in these amendments, if we can get them to believe that that is the goal of the American Republic, then that will act as a brake on the majority from harming the minority. And in essence, what he's saying is you could shame people into behaving like angels. And this was an incredible goal, and I don't think Madison ever thought it would happen. And yet, here we are, and if you polled everybody in this room, everybody in the room would say, I believe that the Bill of Rights is one of the things that makes America great and different from the rest of the world, and these are our values, and this is what we strive for, and this is what we believe in. And that was exactly what Madison hoped for, and at the time thought it would probably never happen, but it was a goal worth achieving.
That's great. So my next question for you is about really a perennial struggle in American politics, which is the struggle between those favoring greater national authority and those who favor states' rights. And
Right.
How did that contribute to this debate in particular?
Okay, a little history lesson from before the Bill of Rights. The Revolution, most people thought that the purpose of the Revolution was to establish the sovereignty of their colony that became a state. When they said no taxation without representation, which was their motto, they meant taxation by their own local government. They had always had a colonial legislature, but they had a governor who represented the empire, and they were going to fight a war to get rid of him and the power of that empire. And the result would be that their legislature would govern them. There were a lot of reasons to want this. One of the reasons was you could watch them. You would know what they were doing, and you could make sure they weren't doing anything tyrannical or oppressive. They lived among you. They earned their living the same way you did. Americans were obsessed in many ways with actual representation, with people who actually were like them, maybe richer, maybe better educated, but came from among them, governing them. So the Articles of Confederation satisfied the goals of the American Revolution. You're fighting against a distant tyrant. You don't want to create a national government that is far away from you. You live in Georgia and they put the government in New York, it may as well be on the moon. There's no internet, there's no email, there's no television, there's no trains, there's no planes. You're going to travel by horseback to see what people are doing in New York. So let's not have a strong national government because that leads to tyranny and oppression. Don't let it tax. Then it can't oppress you economically. Don't let it control your local economy. Let your own people do that. And so you get the Confederation, which has virtually no power. I think it can create a post office. But it fits what they thought they were fighting for. People in the 18th century in America were localists. That is, literally, because the transportation communication revolution was in the future, they lived and died where they were, and they were localists in the sense that that's what they thought the revolution was about. But when a revolution is over, sometimes the goals it has don't keep a nation going. And so men like Madison, Hamilton, Gouverneur Morris, Robert Morris, George Washington said, we really need a national government. We really need a government that can regulate commerce for the whole country, because without it, we're never going to pull out of this post-war depression. We really need a uniform currency. We really need a government that can pay off the debts that this country has so that other countries won't think we're deadbeats. And so they proposed the Constitution, but there were still many, many political leaders who thought this was a terrible idea. who thought that this was a guarantee that we would have a government just like the oppressive English government before you could turn around. And they opposed the ratification of the Constitution. They were called the Anti-Federalists, and Hamilton and Madison were called the Federalists. They almost prevented the ratification of the Constitution. And when they didn't, all was not well. I mean, they didn't go home and say, oh, okay, that's fine. They still wanted to eviscerate the Constitution. They still wanted to do somehow to amend that document so that government couldn't raise taxes, that government couldn't regulate commerce, that government couldn't have its own judiciary. They were still determined, and they saw that as protecting the legacy of the revolution. I mean, they really believed in what they were doing. It's also true that they also were big cheeses, if you will, in their own state government. And the more power that disappeared to the national government, the less power they had. And they had egos enough to be worried about that. This fight, which sometimes historians and people talk as if, well, once the Constitution was ratified, that was the end of that. It was not over. It was not over. And men like Patrick Henry are still trying to arrange for a second constitutional convention to be held to correct the errors that were made in the first constitutional convention. And this is what Madison is trying to avert. Actually, he's trying to crush when he proposes the Bill of Rights.
That's a perfect segue into my next question, and you've already addressed parts of this, which is his larger motive in controlling tyranny of the majority, and then also his motive in crushing a call for a second constitutional convention. They had a hard enough time agreeing here in Philadelphia to the document that they came up with. But he had another more immediate motive in mind.
He wanted, well, for one thing, he'd made a campaign promise. Right. He promised in Virginia when he was running for the House. Patrick Henry was the powerhouse in Virginia at the time, Virginia, the most populous and richest state at the time. Patrick Henry opposed the Constitution. Patrick Henry is a perfect example of localism. His entire life, he referred to Virginia as his country. Not as his state, his country. And so he wanted someone to run against Madison, because Madison was a well-known, at the time, ardent nationalist. And he nominates James Monroe. And they run a campaign in which they say, James Madison thinks the Constitution is so perfect he won't stand for a single word of it to be changed, and he is going to support the oppression of the people. And Madison has to respond, and he says, I will propose a statement of the rights and liberties of the people as soon as I get into Congress. And he's elected, and he feels he ought to honor that promise. But that's really not what's on his mind. What's on his mind, he's a very shrewd politician. He says, what we need to do, now that we have a Federalist Congress and a Federalist President, what we need to do is we need to get credit for passing a Bill of Rights. The Federalists need to get that credit. We need to be the ones who pass the Bill of Rights, and this will, in effect, separate the base from the leadership. Because the people who listened to the anti-Federalist leaders were ordinary citizens who decided, I don't know, maybe it's going to be tyrannical. It doesn't have a Bill of Rights. Don't they believe in our rights? Don't they support our rights? And the anti-Federalists had pushed this really hard in the ratifying conventions. And Madison said, let's steal their thunder. Let's take that fear, and let's us be the ones who say, here's a Bill of Rights, and that will destroy the base of the anti-Federalists. Pretty clever. He's a good politician. He understands how to deal with emotional responses on the part of the people who are still very wary about the Constitution. a lot of Americans were still, I don't know whether this is a good idea, it could be tyrannical, it could be, they could tax us a lot, we're not sure we like this. And so this is Madison's, I think, central political goal. Will destroy the following of the anti-federalist leadership.
So, as you know, but some in the audience and at home may not know, is that many of the states during their ratifying conventions actually drafted out a number of amendments that first they tried to condition their ratification on
Right.
you have to agree to these amendments. That was a no-go, but they suggested amendments. Madison, undoubtedly was aware of these.
Oh, yeah.
But ultimately introduced into Congress his own slate of amendments. What was included in that initial proposal?
Well, he took the 120 proposals that had come in, and he sorted out the ones that were repetitions, and he put them all together. And the ones he did not include in his proposals were the ones that said, take away the power to tax, take away the power to regulate, which were part of the proposals for amendments that many of the states had put forward. So he's designing his proposals to make sure that those issues don't get involved. He proposes about 39. Madison, wonderful guy, very wordy, very wordy. So he proposes this huge number, and they're all in passive voice, and they're all quite long, and they have a lot of clauses in them. And he has about 39 of them. He doesn't propose them as amendments as we know amendments. He proposes them as literally amending the Constitution itself. That is, he wants these things put right in the Constitution. And so every one of these proposals, he calls them, every one of them says, and this should go in Article 1, Clause 4, line 7. And the House, when they finally agree to discuss this issue, the House says, let's give this to a committee of 11, and they actually condense a lot of these. So what we know now as the First Amendment for Madison was 6 or 7 or 8 propositions, and they condense it into one. They condense a lot of his statements into declarative sentences, and they get it down to 12 amendments. And so it has the content Madison proposed, but it's organized in really a much more efficient and readable fashion.
I was going to talk about this a little bit later, but I think it's appropriate to bring it up now. Why did the House ultimately decide, really the Congress in general, ultimately decide not to go in and amend each article and section directly with this language? Instead, they submitted it as a supplement to the Constitution.
There are people who are very, very concerned about the American public accepting the Constitution as the government of the land. And they say, if you start marking it up, if you start changing it, you'll be sending the message that, oops, the convention really didn't know what it was doing, it made a lot of errors, and then that will encourage people to say, well, let's start all over again, which is what the Anti-Federalists wanted. So they said, don't touch the original document. Roger Sherman was the leader of this movement, and he had a much more principled argument. Roger Sherman from Connecticut said, that document was approved by the people of every state, and we do not have the right to touch it. If we want to amend the Constitution, then we have to literally write amendments that come after it, but we can't amend the document itself is sacred. We can't amend that document. He doesn't win the first 2 times Sherman proposes this, but at the very last round of discussions, he proposes it again, and the House approves. Madison's very upset. He really does not want these propositions to be separate from the body of the Constitution, but he loses that argument.
Right.
And they become they intend the first 12 amendments, but they become the first 10 amendments.
So the House of Representatives, the members, and I should mention that in Carol's book, she actually provides really short biographies that are highly informative about all of the members of the First Federal Congress, which makes this a great educational resource. They respond to the proposal in different ways. So there's the substantive response, which you've started to talk about, and we'll talk a little bit more about later, but there's another response, which is, why are we talking about this?
Yes, Madison proposes this, and he thinks everybody is going to say, great idea. And everybody says, oh, come on, what are you talking about? They're annoyed beyond belief. One group says, we already went through this in the Delegates Convention, which is what we call the Constitutional Convention. We already went through this. We don't need it because the federal Constitution gives us absolutely no power to intervene in the rights and liberties of the people. That all belongs to the states. So why should we bother to write a Bill of Rights? Why should we bother to talk about these rights when we don't have any power to deal with them at all? Another group says, why are you raising such an unimportant point? We have important things to do. We have to set the import duties. We have to design the judiciary. And the thing that they were most concerned about, we have to decide where the permanent base of the capital, where the capital's going to be. Go away, you're bothering us. Go away. And Madison is really amazed. And he says, no, and he raises it again. And people say, fine, we'll talk about it later. We'll talk about it later. And it takes a month before they finally give in and they say, okay, let's talk about your propositions, your proposals. Let's take a look at them. And he's really stunned. Usually Madison is politically astute. On this one, he was way off base.
So the House of Representatives, unlike the Senate at the time, its proceedings were generally speaking open to the public. The press, as it does now, covered the proceedings. And Madison's proposals made their way into newspapers, which were distributed around the country. What was the general response of political leaders in other places in the country to his proposals?
Everybody who supported the Federalists said, this is a big waste of time. Fisher Ames, people lit into him. Why are you doing this? This is just, you're doing it for your own career. You're doing it because you want to be important in Virginia. You're doing it because you're afraid you'll lose your seat in the House. They begin to call it a parchment barrier. They say, in effect, this is not worth the paper it's written on. The government has no power to be involved with this, so it's just a parchment barrier to oppression. And then they begin to call it a tub to a whale. They borrow this from Jonathan Swift writes a little satire about whalers who, when they think they're in danger, throw a tub out to distract the whale, to draw them away from the boat. Let them chase the tub instead. And so Madison is lambasted both in the press and in letters from friends. You know this is just a tub to a whale. You know this is just a tub to... And Madison is very, both surprised and very hurt by the fact that people are fundamentally saying this is a waste of time.
So after the Committee of 11, or the Select Committee as it was known then, takes a look at Madison's proposals, condenses them down, changes the writing, and submits it back to the full House, the Committee of the Whole, as they called it. What's the response? A lot of these amendments are in reaction to experiences they had had when they were part of the British Empire. So you and I might think, no right to have the army housed in private homes. And we would say, why was that an issue? Because in fact, that's what the British Army did. They demanded that soldiers be housed in American colonist homes and that these people be fed and taken care of. And this was, for many people, quite a burden.
And so that, everybody approved that. Most of these amendments, people in Congress, when they finally said, okay, let's do this, let's humor Madison, let's get down to it, several of them were just not debated much at all. But a small number of them, there were real fireworks. And I have to tell you that reading every page, every word of the congressional debates, a lot of it is a little dry, but some of it is hilarious because these people are not, as my students always think of them, in Roman togas, brilliant philosophical statements coming out of their mouths. Some of these fellows were dim light bulbs. Some of them were a little wacky. Some of them were pains in the neck. Elbridge Gerry, who is now one of my favorite people, who drove everyone crazy. Finally, at one point, someone says, if a certain person will stop standing up and speaking 5 times and saying the same thing on every issue, we could go home in September. Elbridge Gerry caused a lot of trouble. So there were four amendments that really were critically important. The first was what became for us the First Amendment,
was the third.
The Third Amendment, the Anti-Federalists in Congress, who were a minority, pushed very hard to include, along with the right of the people to assemble and freedom of speech and freedom of religion, pushed to include the phrase, the right of the people to instruct, to give binding instructions to their representatives. And you may think, It summed up in those few words the difference in attitudes about what representative government was. The Federalists believed that you elected men you trusted and respected, and then you left them to make decisions, independent decisions that were in your best interest. And the whole goal of these men who you elected was to be separate from the whims, the momentary passions, the mistaken views of the general populace. To say binding instructions presented a very different view of representation, and that was that the representative you elected to the House of Representatives spoke what you wanted directly. What the people who elected him wanted, that's what he must vote for, that's what he must argue for, that's what he must present. Generally, we have that approach today. We have that attitude today. But the Federalists thought that that was the worst idea in the world because people were irrational. People could want something suddenly and it was not really good for them. And so they did not want binding instruction. And that was a down and dirty argument and a fight. And the Federalists win. As the debates go on, Madison's fellow Federalists begin to like the power that they have. They begin to like the fact that they can vote down anything the minority wants to put forward. And so that was a big argument. The second big argument was what became our Second Amendment. And I want to preface this by saying I have read every word that they said on the Second Amendment. If you have read every word that they've said, we can have a conversation. They did not ever mention individual ownership of guns. That doesn't mean that they said you can't own a gun. They just said nothing about it at all, because that amendment was, again, about states' rights and federal government tyranny. They wanted to ensure that every state was entitled to maintain its own army, its militia, in case the federal government attacked them. In case the federal government became as bad as the British or as bad as the Tsar of Russia and mobilized an army and attacked Virginia, Virginia wanted to have its own army, its own militia. And so that's what they were defending. That's what this bill, this section, this proposal was about. But they had hysterical conversations in the meantime. Should we include that if you belonged to a religion that was a pacifist religion, that you didn't have to serve in the militia when the militia was mustered, called together? Well, yes, we should let the Moravians, that's who they mention most often, not the Quakers, but they meant the Quakers, the Moravians. We should let the Moravians not have to serve in the militia, but they should have to pay to send someone in their place. So Roger Sherman, who is really the most rational person stands up and he says, I'm not sure that people whose religious faith includes pacifism are going to be willing to pay to have somebody go kill people. So I don't think that's going to work. So they say, okay, well, we won't do that. Then someone else says, well, we have to name the religions really specifically. And then someone else stands up and he says, but if you name Quakers and you're a Quaker and you want to fight, does that mean you can't? Well, Nathaniel Greene, one of the most famous generals, had been a Quaker and he wanted to fight. And then they go, oh, well, maybe we should name the religions. And then the most incredible statement comes out, and I'm sitting there reading page after page, and I come across this and I think, thank you, God, this is hilarious. He stands up and he says, we all know that Americans are not religious. We all know that religion is fading in this country. They're not going to church. People aren't going to church. And if you tell the Moravians and the Quakers that they don't have to fight, if our country is invaded by France or England, everybody is going to say they're a Moravian, so they don't have to fight. And some of the responses from other people in the room are like, are you kidding? What are you talking about? And that occupies an enormous amount. Those two issues, should you name the religion, shouldn't you? Should they send in alternatives, substitutes for them? Should Quakers be allowed to participate? Those are all major parts of this discussion about what we call the Second Amendment. At no point does anybody ever say whether she should be able to have a gun or I should be able to have a gun. That was not on their mind. But you can see the terror about tyranny, in that every state wanted to make sure that they could arm their own people and protect their state against the national government. The third great debate, which Madison actually wins in the House but loses in the Senate, is he's at this time in his life an ardent nationalist. Within 2 years, he's going to be anti-administration. But right now, he's an ardent nationalist. He wants the federal government to have power over the states. He did in the Constitutional Convention, and he does now. So he includes the phrase that the federal government has the right to step in if a state abuses the liberties and freedoms and rights of their people, which is exactly what the 14th Amendment winds up saying. And the Senate, who have their seats because they're chosen by the legislature in their states. We don't have direct election of senators till the turn of the 20th century. They owe their seats in government to their own state legislatures. They do not want to go back and say, oh, and by the way, we gave away an enormous amount of your power. And so they veto that phrase in Madison's, in the 12 amendments that are sent up. And Madison is really devastated. He really wanted that included. And the last and probably most important debate they had was over a single word, the word expressly. The 10th Amendment says any power not granted to the federal government or not granted to the state, not granted to the federal government belongs to the states or the people. the Anti-Federalists wanted the word expressly put in. Any power not expressly granted to the federal government, which would mean the necessary and proper clause and all implied powers would be null. If you put expressly, the federal government could only do what was literally written on the page of the Constitution. That would mean no Bank of the United States, no Louisiana, none of the many things that we have done under the necessary and proper clause. And Madison really held his breath. And the Federalists voted down the use of the word expressly. And this, more than anything, made the Anti-Federalists furious. People get up, representatives, especially from Georgia and South Carolina, get up and they say, you have insulted the people of my state. And so those were the four big fights. Everything else, pretty much, everybody said, sure, right, yeah. Oh, no, I forgot one. It wasn't major, but it's funny. They're getting to no cruel and unusual punishment. And a fellow who has not said a word in the entire debate stands up and he says, I don't know about this phrase. He says, some men just need to be whipped. So that was not a serious debate, but I thought that was a charming little moment of some men just deserve to be whipped. They need to be whipped.
It's interesting that you end with that. It's almost like you've seen these questions that I'm going to ask before. Because we have so much information about how the House deliberated on this, some of it lively, some of it a little drier. We don't have that kind of information when it comes to the Senate. So a lot of what we have based on letters, right. Some of it is based on inference. Right. But we know that the Senate makes changes to the House proposal. Can you tell us a little bit about those changes?
The Senate met in secret, which fit the Federalist notion that you deliberated without any outside influence. And a lot of what we know about what went on in the Senate comes from, oh, now I'm having a senior moment, the Pennsylvania diarist, right. Maclay, who wrote everything that happened in the Senate. And he gets sick the day that they're debating the Bill of Rights. And so he's not there. And you're sitting there going, oh, why didn't you have aspirin at the time? Why didn't you have Dayquil? Why couldn't you have gotten to the... We know from letters that members of the Senate wrote later that there were some things that were hot issues and some things that were not. And we know that one of the major ones was this statement that you could reach down into the states. They get rid of that.
And let's talk a little bit structurally. The Senate's a little bit different structurally at this time than it is now in terms of how they're selected. So there's a real reason for their strong reaction against that.
They owed their seat in the Senate to their friends in the legislature who represented the interests of the state. Today, you have general elections of senators, but they're very conscious that they don't want to go home and say, yes, we voted to take away some of our power. And so they X that out of the Bill of Rights. Otherwise, they have a committee then that meets, the Senate and the House have a committee that meet to iron out a few other things. But by the time they get to that, everybody sort of lost interest. I mean, everybody says, some of the Federalists begin to realize what Madison's strategy is. And in part because people outside of the government are saying, you're, tub to a whale, you're doing this to distract people from taxation and currency and economics. And also you're really doing this to humiliate the anti-federalists. And so some of the Federalists really realized this, and they go, good idea, Jemmy. They called James Madison Jemmy. Good idea. Actually, they called him Little Jemmy because he was short.
So in that way, he would have fit in on this stage.
Yes, he would have fit in on the stage completely. He was about our size and much more neurotic than us, I have to say. Hypochondriac, had anxiety attacks all the time. Now I distracted myself. The committee that meets to discuss it from the House and the Senate, really, there's no fireworks, there's no big issue. And then it's sent to the states. And over the course of, Virginia really is not happy, but the states ratify it. 3 states don't ratify it at all. Georgia rejects it. Georgia is very anti-federalist, very states' rights, and they reject it. But Connecticut and Massachusetts don't ratify it either. Those 3 states ratified the Bill of Rights in 1939. In Massachusetts, it's a kind of bureaucratic mix-up. They have 3 or 4 different committees, and they vote yes, and then they vote no, and then they vote yes, and then someone's supposed to send the results of the vote to Thomas Jefferson, who's the secretary, and they just forget. They forget to do it, so they don't ratify it. Connecticut is angry about something, and they won't send in a ratification. And so they get enough states, and here's how unimportant the Bill of Rights were. When Thomas Jefferson sends out a statement of what the government has passed to the states, he lists fishing rights issues before the Bill of Rights. He says, basically, we did this, we did that, we passed these fishing rights regulations, and we also ratified the Bill of Rights.
Which is so interesting for Jefferson, right? Because he cares about declarations of rights.
Yes, he was really pressing Madison to do this. Madison writes to him and says, you know, I promised that I would. Do you think I should? And Jefferson says, yes, absolutely. The federal government ought to have a statement of the rights of the people, too. Even if it has no power, it's the right thing to do. But by the time you get to 1791, Jefferson, nobody seems to care. And there it sits, as I said, until the 14th Amendment.
So now we have just enough time to take a couple of audience questions. We have a lot of questions on the Second Amendment, which I will condense into one question. But I'm going to ask you non-Second Amendment related questions first. This one's a lengthier one. I'm going to read it in full. What do you make of Madison's now largely forgotten initial proposed amendment to the preamble stating that the people's indubitable, unalienable, and indefeasible right to reform or change their government whenever it be adverse or inadequate to the purposes of its institution? Kudos to whoever directly quoted this.
Yes.
And every time I read this, I think, gosh, you know, Thomas Jefferson, when he wrote the Declaration of Independence, and you talk about this in your book, is so much more eloquent than Madison, who tends to be more legalistic in his writing. And reading this again, I'm reminded of it. There's a second part to this question. On its face, this amendment seems to point toward the majority's right to alter or abolish the Constitution, perhaps even outside of Article 5. This would then seem to put into question the perception of Madison as the champion of minority rights.
The reason he wants to put that in the preamble, at least as he said, what he says, is he wants to overcome some sense that you cannot touch this sacred document. He wants to put in he wants to say we really have a right to amend the Constitution. And he puts it in this long, full of commas and semicolons statement. But that's really what he's doing. He's trying to defend the fact that he's proposing amendments. I think knowing that he is, at this time, and he says he is, really an ardent nationalist, it's unlikely that what he was saying go right ahead and get rid of the Constitution. I think what he was saying was, don't anybody panic, we have a right. The representatives of the people have a right to propose amendments to the Constitution.
So this is an adaptation of a question. So it's an audience question plus one of my own. And I think that it is sort of related to another project that you're working on, which is Madison is clearly in the nationalist camp at this point. But later, in the first Congress, right, he separates from his friend Alexander Hamilton over the National Bank. And talk about that evolution. How does he pull away from what he views as the extreme nationalism of Alexander Hamilton as we go along in the first Congress?
Remember, he's a Virginian, and he's surrounded by anti-federalists really at home. He thinks that Madison's, it's not the bank that is the final blow, it's the assumption of the state debts, and it's the payment of the public debt to whoever is holding the certificates. The Confederation government would take your horses or your crop or your weapons or your something and write you a certificate that said the government promises to pay you for what we took and this is how much we owe you. And then, of course, since the Confederation government couldn't tax and depended on requisitions from the states, you know how well voluntary donations go, they couldn't pay this money back. They couldn't pay their soldiers what they owed them. They couldn't pay widows who had given things that they to the army. They couldn't pay anybody. They couldn't pay France. They couldn't pay Holland. So Hamilton says, we've got to fund the debt. We've got to find a way to say that we absolutely will pay a certain percentage of our revenue every year on the spot, no exceptions made, to pay off our debt. And we have to pay off our domestic debt. And we have to pay it off to whoever is holding those certificates. Well, farmers and soldiers who had waited years to get their money were desperate, and speculators came in and they said, okay, we'll take them off your hand at an eighth of what, you know, if it says $10, we'll give you $1 for it. And the farmer said, okay, $1 in the hand is worth, you know, many in the bush. And so the speculators, or the, as they called themselves, the patriots who helped out the farmers and gave them some money when they needed it, now were holding a document that said $10, and Hamilton was going to honor at face value. Madison thought this was horrible. He thought it was immoral. He thought it was terrible. He said, you have to find the original holders. And Hamilton said, yeah, how? I mean, really, we're going to send out a squad of 7 million people to find, track down the original holders. It's impractical to do, and we can't do it. And Madison agreed it was impractical, but he thought that Hamilton was being not only immoral, but where were most of the speculators from? The northern states. And Madison now suddenly takes a Virginia point of view, and he says, commerce and finance are going to benefit from this government, and agriculture is going to suffer, and my family has a plantation, and I'm no longer a nationalist. I'm a states sovereignty kind of guy. And he teams up with Jefferson, and you know, they write the Virginia and Kentucky resolutions, which are the fundamental first statement of, my state doesn't like the law that the federal government passed, so we're not going to obey it. And later, in South Carolina, with the nullification controversy, and then with that little event we call the Civil War, this is the first real declarative statement of that position, that the state has the power to declare a federal government null and void. So Madison really makes a swing.
So what we today would call either depending on how you want to talk about it, a flip-flop or an evolution?
An evolution.
An evolution.
I think in his case it really is an evolution.
Yeah.
He really begins to realize, in effect, that with Hamilton's policies and programs, we've created a monster. We've created a northern and commercial financial monster, and it's going to oppress the people of agricultural states.
This is related in a way, and again, I'm going to add an addendum to the audience question. What role did the issue of slavery play in the initial debates over the Bill of Rights, and then later, what role did it play in transforming the meaning of the Bill of Rights?
Well, in the initial discussion, the answer is simple: none. None of the discussion about Madison's proposals or about the select committee's proposals or about what was finally sent out, slavery was not an issue in them. Slavery becomes the wedge, right, the end of slavery, and the desire of the radical Republicans to protect freed men and, I started to say and women, but really freed men, in the form of Confederacy. That's what leads to the 14th Amendment, and that then becomes the way in which the federal government can step in to protect the rights of African American former slaves. But it's not part of the Bill of Rights discussion.
And then how about after the passage of the 14th Amendment?
The truth is that though it was used briefly to uphold the rights, particularly of black male voters in the South, who of course were voting for the party of Lincoln and the party who freed them, by 1876, with what they call the Warmley House bargain, that was a hotel where the Democrats, Tilden and the representatives of Hayes, sat down and said, horse traded, and they said, okay, we'll give up keeping the army in the South to protect black voters if you'll give the election to us. And Tilden said, sure. The Democratic candidate said, sure, and that ended Reconstruction, and that really ended the discussion.
Until the 20th century.
Until the 20th century. The Bill of Rights does not become really important in judicial decisions. It's not cited in judicial decisions as the basis for the opinions until the 1930s. I mean, that's a long time after the Bill of Rights is passed.
So our next question is about the Alien and Sedition Acts. So the questioner says that this is really one of the first big challenges to the Bill of Rights.
I want to say that is absolutely true. The argument is much less, however, the reason I didn't mention it, the attack on the Alien and Sedition Acts is much less about this is an attack on the Bill of Rights than it is this is an attack on state sovereignty. What the people who oppose the Alien and Sedition Acts say is you cannot say who can stay in our state. You can't, the Alien Act said if anybody is dangerous to the federal government, one of them said, then we can deport them. And so the complaint was less about, no, that's not what the Bill of Rights says. The complaint was, you can't tell the state of Virginia that we have to deport someone that we think is okay to live here. And the argument about the Sedition Act, which was to suppress newspapers, it was a blatant out-and-out Federalist attack on Republican newspapers. I mean, that's really, everybody knew that's what it was. The argument was, you can't tell our state what newspapers can function in our state and what newspapers can't. So they're much more, and that's what the Virginia and Kentucky resolves are really about, states' rights, state sovereignty. And so, though it is tangentially about the First Amendment, it's really much more about states' rights, the attack on the Alien and Sedition Acts.
So this is another interesting question. One of the main arguments advocates put forth during this period against the Bill of Rights was that by failing to fully enumerate all rights natural to mankind, the natural rights of the people could actually be unnecessarily circumscribed. Do you see any truth to that claim? And then there's another interesting question, which is, what about the people's right to change the Constitution whenever and however they see fit?
Well, the Constitution has the right to amend it.
Unfortunately, not whenever and however. Article 5 spells out how you can amend the Constitution, and because that bar is high, that means that you're unlikely, right? There have been thousands of amendments proposed, only 27
Right.
Passed and ratified,
Right.
and we got 10 of them, really actually 11 of them, at the same time.
Right. Well, whenever and however is the question.
Yeah.
I mean, by revolution, the men who led the revolution wanted the revolution over. They did not want more revolutions. But the first question was,
In retrospect, do you see any truth to these claims?
To larger human rights. There is certainly, not in the debates, but there are certainly externally, there are discussions about all humankind, because remember, the French Revolution is going on at this very moment. But Madison's proposals, and many of these first 10 or 12 amendments, are really very specifically about you should be able to be tried in your own vicinage, that is, in your own community, no cruel and unusual punishment, you have a right to not incriminate yourself. These are very specific legal rights, and they're basically sort of taken out of the common law tradition. They're not great philosophical statements. And even the First Amendment is really about American citizens, the American citizens' rights to do certain things. And they certainly don't apply to African Americans. African American slaves are not entitled to assemble and discuss things. So I think it would be a mistake to think that on the issue of the Bill of Rights, people were thinking globally, were thinking about all human rights. They were really very specifically thinking about what do the rights of people in this republic. They do talk about natural rights. Some things are natural rights. But if you look at those 12 amendments, most of those are really about, a lot of them have to do with the legal, your rights in a court of law, or your rights in terms of dealing with changing the Constitution or what the Constitution says, that expressly argument, the right to instruct your representatives. These are not large philosophical enlightenment rights. These are very specific to the American government.
Yeah, I think just to follow up on this questioner's comment here, and I think this was a genuine concern at the time, that by enumerating these rights, it would be assumed, Americans, these are your rights. And no other, and Madison tries to write a corrective, and some people would argue today maybe that corrective has been largely ignored, the Ninth Amendment.
Everybody is very concerned. What if you leave something out? What if, even in the Constitutional Convention, that was why they said this is going to take forever to do, because if we leave something out, does that mean that people don't have that right? And that's why the 10th Amendment says anything not expressly, and the 9th Amendment says anything not enumerated doesn't mean that you don't have that right. They were all very conscious of that, you know, we might not mention something, we might forget something, and it doesn't mean that you don't have that right. Today, I don't know, is that?
Well, it all comes in through the due process clause.
Right.
And you could argue about that, 9 unelected people coming up with those things.
Right.
Sort of outside the scope of this discussion, at least, although I know they talk about that here at the National Constitution Center. The last question is an interesting one, and actually one that I haven't studied, and I don't know if this is something you looked into. But the Bill of Rights was really limited to white men,
Yeah.
as the Constitution was. When you were doing your research, did you come across anyone contesting that?
No. No. And it wasn't even limited to all white men, because you had to still, the states, the federal government had no control over who could vote. No, that was not part of their power. That was left to the states. And a lot of states had rules that came from the English tradition. You had to have a 40-shilling freehold. That is, you had to own land, not rent land. And there were, in some states, great debates about whether inventories in shops counted as property. They really meant real estate, real property. And it comes back to the idea of voting in the 18th century, which is not the same as what we think, which is a good way to end about how these things change. In the 18th century, voting was like a poker game. You had to ante up. You had to have something you might lose before you could participate in making laws and picking the people who made the laws. And that something was real property. You had to be an independent owner of something, because then you wouldn't pass insane laws. You wouldn't vote for people who would pass insane laws, such as, you have too much property, give me some. So there were men who were renters, there were men who were apprentices, there were men who were journeymen, there were men who didn't own property. They couldn't vote. That's a 1820s, all white men can vote. Today we think if you're born in this country and you're a citizen of this country, you have the right to vote. They would have thought you were crazy. They would have been amazed by some notion like that. And so it was not only about white men, it was about particular white men. And those were the white men who had a stake in society. And I will tell you, my students always write an S-T-E-A-K, a stake in society. And Michael knows when I'm feeling feisty, I write in the margin, porterhouse or T-bone?
And I guess with that, we will let people go adjourn to a hopefully nice steak dinner. E-A-K, not A-K-E.
Right.
That might be less than pleasant. But please join me in thanking Carol for, it was really a wonderful discussion.
Thank you.
As I mentioned, her book is for sale, and she is signing it, and I'm going to be the first one to ask her to sign my copy.
Where am I doing that? Out in the lobby, I think.
Out in the lobby.